Good afternoon, and welcome to this week's webinar presented by Beresford Booth. My name is Per Oscarsson. I'm a member of the Estate Planning and Probate group here at the firm. And my topic today is, what is a durable power of attorney and how does it work? That may seem obvious, but to many it may not be. So in this webinar, I'll be talking about what's the definition of a power of attorney, what makes that power of attorney durable, when is the power of attorney effective, any special requirements and restrictions on powers of attorney, and then how a power of attorney works. So first, the definition of a power of attorney. It's a writing that uses the term power of attorney, and it grants authority to an agent to act in place of the principal. I have heard of some people thinking that it may have something to do with transferring property, maybe even upon death. It does not have that effect at all. It may allow an agent or attorney, in fact, to transfer the principal's property during the principal's lifetime, but not after death. So the power of attorney document, as you see, it has to be in writing. It has to be signed and dated by the principal, and I'll get into some definitions here in just a second. That signature needs to be properly notarized or acknowledged. That could be a notary public. It could be someone else who's authorized by law to take acknowledgments. Judges can serve to acknowledge documents as an example. Or it is to be witnessed by two or more competent witnesses. Competent meaning, for example, if someone is living in a long-term living facility other than their home or apartment, the witnesses cannot be employees of such a facility. They also cannot be related to, the witnesses also cannot be related to either the principal or the agent by blood or marriage. So the principal is the person who is granting the power of attorney to someone else to act on their behalf. The agent or attorney, in fact, is the person or persons who is granted the authority to act. Incapacity is probably the biggest one, potentially difficult definition. And this is by statute, it's the inability of an individual to manage their property, business, personal, or healthcare affairs because either the individual has an impairment in the ability to receive and evaluate information or to make or communicate decisions. What you may not think of as being an incapacity is being an absentee as defined by statute, or being outside the United States and unable to return. For example, maybe traveling abroad and injured and in a hospital. You may not be totally incapacitated in that you can make decisions for yourself, but you're just not able to be able to get back to the U.S. So what makes the power of attorney durable? Generally, a power of attorney terminates upon the incapacity of the principal. So there is kind of the difference between durable and undurable or non-durable is merely some language in the document. The power of attorney can be almost identical, but is it durable or not durable? So durable power of attorney is if the writing itself that creates the power of attorney contains the words, this power of attorney shall not be affected by disability of the principal, or this power of attorney shall become effective upon the disability of the principal, or some similar language that indicates the principal's intent that the authority granted is to be exercisable by the agent, even though the principal may have an incapacity. So the difference between a non-durable or durable power of attorney, it kind of comes down to when can it be used. With the non-durable, or undurable. It cannot be used if the principal has become incapacitated. If it's durable, it can be done that way. And the powers of the agent are not determined by whether or not the power of attorney is a durable power of attorney. So effectiveness. It can be effective when executed, which means that as soon as the document has been executed and properly acknowledged or witnessed, the attorney, in fact, has the authority to act. If the principal is not incapacitated, hopefully the attorney, in fact, is not making decisions, particularly those that they may be contrary to what the principal would decide. If there's a conflict between those two decisions and the principal has not been suffering or is not suffering an incapacity, the decision of the principal should be the one that's followed. This has been an issue that I have seen with people saying, well, what if my attorney in fact takes action while I still have my capacity? And my response has normally been, if you're concerned about whether the attorney in fact will act when you still have capacity, you may have chosen the wrong person to act on your behalf, because there's a trust issue at that point. The power of attorney could be made to be effective upon some future date or occurrence of a future event or a contingency. Typically, we see it's either effective immediately or it's effective upon an incapacity. It could be one that's kind of springing into effect because something has happened, something other than the principal's incapacity. It could be an event, could be some other kind of contingency. If the power of attorney is to be effective upon the occurrence of a future event or contingency, the principal in the document, in the power of attorney granting document, can authorize one or more persons to determine in writing that event or contingency has happened. Now, the person or persons who would make that determination should not be the person or persons who would serve as attorney in fact under the document. It should be someone else. Again, someone trusted by the principal to make that determination. And if it's effective upon incapacity, the principal may authorize someone to determine whether the principal is incapacitated. Again, that person, if so authorized, should not be the attorney in fact. Clearly, there's a conflict of interest that individual may have or would have if they can make the decision to make the power of attorney that's effective upon incapacity, and that person decides, yeah, the principal is incapacitated. If the principal has not authorized a person to make such a determination, or the person who has been authorized to make such a determination is unable or unwilling to do so, then the power becomes effective upon the determination in writing by a physician or licensed psychologist who's unrelated to the principal or the agent by blood or marriage. That physician or licensed psychologist has personally examined the principal. So just looking at records and hopefully not just listening to what someone else may say is not going to be sufficient. And they have to determine that the principal is incapacitated under the impairment portion of the definition that I previously mentioned in this webinar. Or the power can become effective upon the determination by a judge or an appropriate governmental official that the principal is incapacitated under the absentee or outside the U.S. portion of the definition that I previously mentioned. Now, powers of attorney generally, and I normally distinguish between financial and healthcare. We often do two separate documents. Healthcare powers of attorney being only limited to healthcare, or arranging for maybe a long-term stay or maybe even a short-term stay, for example, in a rehabilitation facility after surgery, as just an example. But with the financial, they are typically very broad, because you could by limiting them, you could unfortunately eliminate the authority of the attorney in fact to take action on certain subjects. So if it's just broadly written to say the attorney in fact can do anything that the principal could do if the principal were able to do it, that's fine. But at least in the state of Washington, and there may be other states that do something similar, the legislature has determined that there are certain authorities that your attorney in fact does not have unless it's specifically granted in the document that grants the power of attorney. So for example, my first bullet point here, creating, amending, revoking, or terminating an inter vivos trust. An inter vivos trust is one that's created during lifetime and is used during lifetime. So if there's nothing in the, in the power of attorney document that grants that authority, the attorney in fact does not have the authority. Second one is making a gift. You may have established some pattern of making gifts, whether it be merely to family members or even broader, could be to friends, to charitable organizations. You can include in a power of attorney document authority to make gifts, and hopefully you will provide some description of what pattern you would like if you want the attorney in fact to have the authority to make gifts. You may include a paragraph or maybe even just a sentence that describes the pattern of your past giving that you would like the attorney in fact to consider when they are making a gift on your behalf. And there could be any number of things. For example, there is a federal annual gift tax exclusion for gifts in 2024. That's $18,000, up to $18,000 to as many individuals as you would like to give. And you may limit the authority of your attorney in fact to make gifts to under that annual gift tax exclusion amount, or you may not limit it. Now, if you don't limit it, you could be giving your attorney in fact and would be giving your attorney in fact the authority to make gifts on which you would be required most likely to file a federal gift tax return. You may not have to pay federal gift tax, but you would most likely have to file a federal gift tax return to indicate how much of your lifetime gift exclusion you have used in that year. Another one is creating or changing rights of survivorship. One of the methods of holding property is joint tenancy with right of survivorship. And it's a method that operates by law, does not operate under a will, for example, and you can create ownership interests in property as joint tenants, but you have to specifically authorize your attorney in fact to do so if you want to do so. And there's nothing that says that you have to authorize your attorney in fact to have any of the authorities that I'm talking about here, or all of the authorities. But you would have to, if you want to include all of them, you would have to specifically include all of them. Another is to create or change a beneficiary designation. This, for example, could be on a life insurance policy, or sometimes various types of accounts like bank accounts or investment accounts may have a payable on death or transfer on death provision, where in the documents that you use to create such an account, you identify a beneficiary or beneficiaries. You would have to give your attorney in fact specific authority to make changes to those kind of designations. Sometimes an attorney in fact is allowed to delegate some of their authority. Now, where we won't talk about where you have co-attorneys in fact, where they can be, each one could take some portion of it. This is maybe where you have an attorney in fact who's delegating something to someone other than another attorney in fact. So for example, maybe they're delegating something to a real estate agent to do on your behalf, or they may be delegating to some other person to handle, possibly if you have property in another state. Another one is waiving the principal's right to be a beneficiary of a joint and survivor annuity. If you've got an annuity, you may have a right to be a beneficiary. This would specific authority for your attorney-in-fact to waive that right. Sometimes the principal has authority to designate fiduciary powers that they may have. So, for example, the principal might be a trustee under a trust, and that trust may allow them to delegate some of their authority. This is kind of a further delegation because it allows if the principal has the authority to delegate some of their fiduciary powers, the principal in that case could authorize their attorney-in-fact to do that. Another is exercising a power of appointment. Power of appointment is another estate planning tool that allows a person to designate either in a limited power of appointment or a general power of appointment the person or persons who should receive certain property that don't belong to the principal, but the principal has been given this power to determine who will receive it. And we won't go into powers of appointment in this webinar, but just know that the ability to exercise that power on behalf of the principal must be specifically provided by the principal to the attorney-in-fact, or the attorney-in-fact does not have it. Creating, amending, or revoking a community property agreement. Community property agreements are used to kind of change some of the state-provided rules on the ownership of property by spouses. There is separate property, typically property that spouses come into a marriage with. It's also certain types of property that they acquired during the marriage. So, for example, if one of the spouses were to inherit property during the marriage, that property would be their separate property. Other property, typically like wages that are earned during the marriage, property that is acquired during the marriage, at least if it's not acquired with what was separate property, because the new property that's acquired with what was separate property coming into the marriage would retain the character as separate property. A community property agreement allows the spouses to change those rules to say, in various ways, they can say, well, anything that was separate property or is separate property under the law during the marriage will be treated as community property. Such an agreement could also provide that upon the death of the first spouse, that all of that spouse's interest in community property automatically vests in the surviving spouse. If there's no community property agreement, that would not hold true, because each spouse in a marriage has the ability to, by will, distribute their 1/2 interest in community property or any of the community property to anyone they wish. That would typically be the surviving spouse, but not always. Sometimes a principal is the beneficiary of a trust and may have the ability under the trust to cause the trustee to distribute property. This final bullet point on this page indicates that if the principal does have that kind of authority, they can delegate that effectively to the attorney-in-fact to direct the trustee to make such a distribution. There are other non-probate transfer at death instruments, like a transfer on death deed, for example, where one person gives another person a deed to real estate that is not to be effective until they die. And there are a number of other types of non-probate assets where the statute allows you to designate that are not treated as testamentary instruments, even though they may only be effective upon death. And then finally, making healthcare decisions for the principal. As I said earlier, sometimes those will be in separate powers of attorney. One may be dealing only with healthcare issues. One may be dealing with financial. They may be in the same document. It kind of depends on whether you have the same individual serving as the attorney-in-fact for both purposes. And that may or may not be true. You may have someone serving as your healthcare attorney-in-fact because they would be great in making a healthcare decision. So, for example, maybe a family member is a doctor or a nurse, and you may want to have them making those decisions on your behalf. Or maybe just be someone, a trusted individual, but they may not be great with the financial decisions. So you may have someone else as the financial attorney, in fact. But for healthcare purposes, you definitely need to specifically identify or grant that authority. So some of the restrictions are that you can, even though a power of attorney may be very broadly written, you can restrict the powers that are to be exercised by the attorney in fact. Sometimes it's by, for example, a limited power of attorney, where it may be limited in, well, very often a sale of real estate. The principal is going to be out of the state or out of the country at the time a transaction closes, and they need someone to act on their behalf, but only for purposes of closing that transaction, whether it be on the seller side or the buyer side. They may authorize an attorney in fact to take action just on that subject, or a broadly written power of attorney document. It may be restricted on certain powers because maybe you don't feel comfortable with the attorney in fact being able to do everything that they might otherwise do on a particular subject area, but you'd be fine with them doing a more limited area. Also, some of them are actually restricted by statute unless the power of attorney document specifies otherwise. And the statute specifically says, unless the power of attorney document provides otherwise, this is the scope of the attorney in fact's authority on this particular subject. So how does the power of attorney work? Well, the agent or attorney in fact can take action either orally or in writing, but they should make clear that they are acting as the agent or attorney in fact for the principal. That should be obvious, but it may not be depending upon the circumstances. And the person who is asked to accept a power of attorney, that is, to accept the actions of an attorney in fact or agent, they may require additional proof that the attorney in fact has the authority to act. You typically probably would not see this where the power of attorney is effective immediately, because as long as you've got a copy of the power of attorney document and it will say it's effective immediately, that should be about the only evidence they need, other than the person being asked to accept the attorney in fact's actions may want to make sure through some sort of proper identification, like a driver's license or something like that, that the attorney in fact is really the attorney in fact that's named in the document. But there may be other things, particularly if there's an issue on, for example, if the power of attorney is effective upon some other contingency or event or incapacity, that has actually been determined. So, for example, where the power of attorney is effective on the occurrence of a future event or contingency, not incapacity, they may want to see the writing where an individual who has been authorized to make that determination or to confirm that event or contingency has occurred. They may want to see that document. Then the power of attorney, where it's a non-durable, as I said earlier, the power terminates when the principal becomes incapacitated. A durable power of attorney becomes or terminates when the principal has died and the agent or attorney in fact knows that the principal has died. There could be some uncertainty about whether the principal has died. A terrible example, but one that could certainly apply, is some sort of an accident, automobile, for example, where the principal may not know, or I'm sorry, the attorney in fact may not know that the principal has been involved in an accident. The principal may have been killed in the accident. They may be in the hospital as a result of the accident. And the attorney in fact, as long as they don't know that the principal has died, they can still act on behalf of the principal. But once they have actual knowledge that the principal has died, then they will lose their authority to act. All of these, as you see in the final bullet point, that the agent may act if they act in good faith, that is one of the requirements for the attorney, in fact, in all cases, whether or not there is uncertainty about the death of the principal, the attorney, in fact, has a duty to the principal to act in good faith on behalf of the principal. That concludes today's webinar. If you have any questions, my telephone number is on the screen. Hopefully you will join us next week. Mackenzie Bretz of the firm's Family Law Department or Family Law Group will be presenting on tips on obtaining a comprehensive civil protection order. Thank you very much.